Welcome to our examination of the movement for women's civil rights. As already noted, the pronouncement in the Declaration of Independence that all men are created equal initially applied only to white men, and usually only to those who owned property. Not only did the concept of equal protection of the laws not apply to non-white male citizens until the Civil War amendments to the Constitution and subsequent pieces of national legislation such as the Voting Rights Act and Civil Rights Act, it also did not apply to female citizens, white or non-white. Like African American men, women had to wait until the Constitution was amended and civil rights legislation was adopted in response to the women's rights movement for equal protection of the laws. Advocates for women's civil rights began their efforts in the mid-1800s, initially focusing on gaining the right to vote for women citizens. That endeavor, the first wave of the women's rights movement, won suffrage for women in 1920. The cause of women's civil rights was rejuvenated in the 1960s when the second wave of the movement began. The second wave continues today. The segregation of the women delegates at the 1840 World Anti-Slavery Conference in London was a defining moment for the first wave of the U.S. women's rights movement. Forced to sit in the balcony behind a drawn curtain, Lucretia Mott and Elizabeth Cady Stanton recognized that without improving their own legal and political status, women were not going to be successful in fighting for the legal rights of other groups of people. In 1848, Mott and Stanton organized a meeting at Seneca Falls, New York, to talk about the lack of legal rights of U.S. citizens who happened to be born female. At the end of the convention, the participants signed the Declaration of Sentiments. This declaration, modeled after the Declaration of Independence, listed many rights and opportunities that the law did not guarantee women, including the right to vote, educational and employment opportunities equal to those of white men, and married women's rights to own property, as well as legal standing to sue. At the end of the convention, the participants signed the Declaration of Sentiments. Clearly, John Adams and the other architects of the Constitution had ignored Abigail Adams' request to her husband and his colleagues to remember the ladies when they created the new system of government. Adams warned her husband that not only would women not feel bound to obey laws in which they had no say, but also the ladies would foment a rebellion if they were not provided a voice in government. The signatories of the Declaration of Sentiments began Adams' forecasted rebellion. The document they signed insisted that women have immediate admission to all rights and privileges which belong to them as citizens of these United States. For those women and men who joined this new movement for women's civil rights, the right to vote became the focal point. They recognized that this right was the foundational right that would enable women to win the other rights and privileges of citizenship. Because the Constitution initially reserved for the states the authority to determine who had the right to vote, as well as to be employed and obtain the best possible education, many of the initial battles for women's rights took place at the state level of government. Eventually, as the national government responsibilities expanded through court interpretations of the Constitution, especially the 14th Amendment, the federal government's role in guaranteeing civil rights expanded. Even after ratification of the 14th Amendment in 1868, guaranteeing equal protection of the laws for all people and the same privileges and immunities to all citizens, women's educational and work opportunities were limited by social norms as well as state laws. Education for girls prepared them to be good wives and mothers, not to be economically independent. By the late 1800s, a few colleges began to admit women, and several women's colleges were established. Yet most colleges did not offer women the same educational opportunities as men, and women who graduated and aspired to a career were limited in two ways. First, by choosing a career, these educated women gave up the possibility of marriage. They were not legally banned from marriage, but societal norms prevented them from having both a career and a husband. Second, their career choices were limited. Teaching, the developing professions of nursing and social work, or missionary work. In 1873, Myra Bradwell challenged women's limited career choices when she sued the state of Illinois over its refusal to let her practice law. She argued that the 14th Amendment's Privileges and Immunities Clause protected her right to earn a living in a career for choice. In this case, the Supreme Court found that women's God-given destiny was to fulfill the noble and benign offices of wife and mother, and that allowing women to practice law would impinge on that destiny. The Bradwell case, Bradwell versus Illinois, established the precedent for the court to justify allowing women to be treated differently from men. sex-based discrimination, if the different treatment was deemed a rational means by which the government could fulfill a legitimate public interest. In the Bradwell case, the court applied the ordinary scrutiny test, deeming it legitimate for the government to protect the role of women as wives and mothers, and to accomplish that protection, it was rational to deny them equal opportunities in employment. In 1875, another women's rights case came before the Supreme Court. In this case, Virginia Minor of Missouri, actually her husband, because she still, like all married women, did not have standing to sue, challenged the constitutionality of the Missouri law that guaranteed the right to vote only to male U.S. citizens. In this case, Minor versus Happersett, the court acknowledged that women were citizens, yet it also decreed that state governments established voting rights, not the U.S. Constitution. Therefore, the justices argued that the 14th Amendment's Privileges and Immunities Clause did not give women's rights did not give women rights not established in the Constitution, hence it did not extend to women the right to vote. Although by 1875 some local governments, school districts specifically, had extended voting rights to women, no state other than New Jersey had ever given women the right to vote. Women who owned property in New Jersey had the right to vote for a brief period between the end of the War for Independence in 1807, when it was taken away in response to the lobbying of politicians and professional men. The American Women's Suffrage Association, directed by Lucy Stone, had been leading the battle to extend the right to vote to women in the states since 1869. Also since 1869, the National Women's Suffrage Association, directed by Susan B. Anthony and Elizabeth Cady Stanton, had been fighting to extend to women all rights of citizenship, including, but not limited to, vote. Unlike the American Women's Suffrage Association, the National Women's Suffrage Association focused its suffrage battle on the federal level, specifically on amending the U.S. Constitution. In 1890, frustrated by their lack of success in the battle to extend suffrage to women, the AWSA and the NWSA joined forces, creating the National American Women's Suffrage Association, or NAWSA. The NAWSA focused its efforts on amending the U.S. Constitution. In 1916, Alice Paul founded the National Women's Party, which adopted more radical tactics than the NAWSA had been willing to use in its fight for suffrage. Noting the lack of support on the part of national officials for suffrage, Paul's organization called on voters in the 1916 election not to vote for candidates who opposed women's suffrage, including President Wilson, who was running for re-election. In 1917, after President Wilson was re-elected, Paul and other suffragists chained themselves to the White House fence and called on Wilson to support the suffrage amendment. Arrested, jailed, and force-fed when they engaged in a hunger strike, the women gained media attention, which in turn brought national attention to their struggle for suffrage and the president's opposition. After several months and persistent media pressure, President Wilson called on the House and the Senate to approve the women's suffrage amendment. By June 1919, the House and the Senate approved what was to become the 19th Amendment. In 1920, Tennessee became the 36th state to ratify the amendment, and it was added to the Constitution. The 19th Amendment prohibited the national and state governments from abridging or denying citizens the right to vote on account of sex. The right to vote was extended to another group of citizens in 1971 when the states ratified the 26th Amendment. This amendment guarantees citizens 18 years of age or older the right to vote. However, college students and civil rights advocates have raised concerns about lack of equal protection of voting rights for college students living away from their parents. After the 19th Amendment was added to the Constitution, the push for women's rights ceased to be a mass movement. Women were still organized in groups and lobbied the government for women's civil rights, but the many women's organizations were no longer working collectively toward one agreed-upon goal, such as the right to vote. Another mass women's movement did not arise until the 1960s. Several factors account for the mobilization of the second wave of the women's movement in the 1960s, which focused this time on the plethora of rights related to the social, economic, and political status of women. Many of the same rights originally demanded in the Declaration of Sentiments. By the 1960s, large numbers of women were working outside the home in the paid labor force. Working women talked with one another about their work and family lives and came to recognize common concerns and problems, including discrimination in educational opportunities, employment opportunities, and pay, lack of child care, domestic violence, the problem of rape, for which they were often blamed, and their inability to obtain credit or borrow money without having a male co-sign on the loan. Women recognized that as a class of citizens, they did not have equal protection of the laws. In 1961, at the prodding of Esther Peterson, the director of the Women's Bureau in the Department of Labor, President John F. Kennedy established a commission on the status of women, chaired by Eleanor Roosevelt. In 1963, the commission reported that women in the United States were discriminated against in many areas of life, including education and employment. In its report, the commission argued that women needed to pursue lawsuits that would allow the Supreme Court to interpret properly the 14th Amendment's Equal Protection Clause, hence prohibiting discrimination against women. By the mid-1960s, the women's rights movement was rejuvenated with a second wave of mass activity. The goal of this second wave was equal rights for women. The means to achieve that goal included public demonstrations, legislation, litigation, and as yet unsuccessful attempt to enact the Equal Rights Amendment, or ERA, which had been written by Alice Paul and first introduced in Congress in 1923. In 1955, Edith Green, a Democrat from Oregon, introduced into Congress the first piece of national legislation written specifically to protect women, the Equal Pay Act. Enacted into law in 1963, the Equal Pay Act prohibited employers from paying women less than men were paid for the same job, which was the standard employment practice at the time. Indeed, beginning with school boards in the mid-1800s and the federal mint during the Civil War, governments had hired women specifically because they could pay them less than men. The 1964 Civil Rights Act, initially drafted, prohibited discrimination in education, employment, and public accommodations based on race, ethnicity, and religion. Yet, because of congressional women's efforts, Title VII of the proposed act was rewritten to prohibit discrimination in all personnel decisions based on sex as well as the other inherent characteristics. Initially, the EEOC, the federal agency responsible for monitoring Title VII implementation, did not take sex-based discrimination complaints seriously. Women serving on state committees on the status of women responded by establishing the National Organization for Women, or NOW, in 1966. NOW's initial statement of purpose is modeled on the request of the 1848 Seneca Falls Declaration of Sentiments, demonstrating the continued lack of progress toward the goal of women's equality under the law. To take advantage of Title VII's promise of equal employment opportunities, women needed to pursue educational opportunities on an equal basis with men. Yet Title VI of the 1964 Civil Rights Act does not prohibit sex-based discrimination in institutions that receive federal funds, including educational institutions. By 1972, women's rights advocates won an amendment to the 1964 Civil Rights Act, Title IX, which prohibits sex-based discrimination in educational institutions receiving federal funds. The Equal Pay Act, Title VII, and Title IX are landmark pieces of national legislation that provide equal protection of the law for women. At the same time that Congress was enacting laws prohibiting sex-based discrimination, the courts were reinterpreting the Equal Protection Clause of the 14th Amendment. In 1971, in the case Reed v. Reed, the Supreme Court, for the first time in history, used the Equal Protection Clause of the 14th Amendment to find a law that discriminated against women unconstitutional. In the Reed case, the Supreme Court found that an Idaho state law giving automatic preference to men to administer the estate of a deceased person who had not named an administrator was not a rational means to fulfill a legitimate government interest. Hence, using the ordinary scrutiny test established in the 1873 Bradwell case, the court ruled this discriminatory treatment of women was unconstitutional. Then, in 1976, the Supreme Court developed a new test for the legality of sex-based discrimination. Oklahoma law allowed women 18 years of age to buy beer with 3.2% alcohol content, yet men in Oklahoma had to be 21 years of age to purchase 3.2 beer. Men challenged the law, asking the court to decide if this sex-based discrimination was constitutional. In this case, Craig v. Boren, the court established the heightened scrutiny test for sex-based discrimination cases. Different treatment is legal if it is substantially related to an important government interest. The court used this test in the Craig case to find the Oklahoma law unconstitutional. The court also used the heightened scrutiny test in the 1996 U.S. v. Virginia case. In this case, the court found the male-only admission policy of the Virginia Military Institute unconstitutional. Justice Ruth Bader Ginsburg noted in her opinion that the state of Virginia had not shown that this discriminatory admissions policy was substantially related to the important government objective of training soldiers. Today, courts sometimes use the ordinary scrutiny test and other times the heightened scrutiny test when deciding sex-based discrimination cases as well as other non-race-based discrimination cases. Proponents of an ERA, or Equal Rights Amendment, argue that the strict scrutiny test, which is used in race, religion, and ethnic-based discrimination cases, should also be used in sex-based discrimination cases, and that this will not happen until the Constitution is amended to explicitly guarantee equality of rights under the law where a person is a man or a woman. During the 1970s, as the Supreme Court was reinterpreting the implications of the 14th Amendment for sex-based discrimination, lobbying for the Equal Rights Amendment increased. In 1972, Congress approved the ERA, which states that equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Finally, 49 years after it was introduced in Congress, the ERA was sent to the states for ratification. Opponents of the ERA argued it was a duplication of the 14th Amendment and therefore was not needed. Opponents also claimed the passage of the amendment would make women subject to the military draft, would lead to the integration of all single-sex institutions, including schools and public bathrooms, and would result in the legalization of public funding for all abortions. Moreover, they argued that the ERA was not needed because Congress was passing laws that guaranteed women equal protection in employment and education. Whether or not the claims of its opponents were accurate, they were successful in defeating the ERA, which had not been ratified by enough states by the deadline of 1982. The first wave of the women's rights movement won the vote through constitutional amendment. The second wave was successfully expanded women's civil rights through litigation and legislation. Yet many women's rights advocates argue that women still battle inequalities, including unequal pay, sexual harassment, and the glass ceiling, aspiring to higher-level jobs but being unable to win them. Although the situation for women has greatly improved, some argue, not all women have benefited equally from gains in women's rights. Non-white women have two characteristics that can lead to discriminatory treatment: gender and color, necessitating a struggle for equal protection on two fronts: the women's rights movement and the civil rights movements for their racial group.